Welcome back. If you're just tuning in tonight, Michelle Carter, the young woman who urged her boyfriend through text messages to kill himself, has been ordered to jail to begin her sentence for involuntary manslaughter. She's set to spend 15 months in the Bristol County House of Corrections.
And joining us now to talk more about the case is Boston attorney Phil Tracy. Phil,
Great
thanks
to be
for
with
coming
you both
in.
Again.
We
Yes.
appreciate it. So our first question, the decision today was that she be sent to serve her sentence right away, no delay. She cannot wait any longer. Did you think that this was a fair decision? Is this
I
the
think
way
it was
should go?
fair and appropriate. She had exhausted, she had excellent attorneys throughout the process. She had Joe Cataldo, the attorney that she had, was an excellent attorney. She had excellent appellate attorneys. They went through the process. They went to the Supreme Court. The Supreme Court says
Supreme Judicial Court.
Supreme Judicial Court. And the Supreme Court unanimously said, this is wrong, and this is wanton, willful conduct. Her forcing him back into that car by words. Words can kill, and in this case, they did.
So there's still a lot of debate about whether or not she should have been convicted in the first place. As you were saying, the Massachusetts Supreme Judicial Court last week upheld unanimously the conviction. But what made this a crime? Some people would say, look, she's just telling him what she thinks he should do.
Using this example, if she was standing on a cliff and she told him to jump, she's right in his proximity then, or if she pushed him. That's different than this. She's far away, and she's using words and electronics, texting and that sort of thing, to encourage him to kill himself. Now, see, that was the issue that people were trying to say, free speech, it's her right to say what she wants, etc. But the court felt this was conduct. These words meant something.
And you say there was a specific moment where she crossed the line.
Badgered him back into the truck.
Because he got out of the truck. We should remind viewers he got out of the truck, and she said, according to prosecutors, get back
in the truck and basically, you know, shamed him into getting back in there, knowing that he was going to die. And then, according to the words of the judge, she waited and heard him choke and die. You know what I mean? So she didn't do anything. She didn't call the police. She didn't call his family. She had some responsibility for his death. Now, other people, I hear from the court of public opinion, nurses, lawyers, housewives, people think this 15 months is too light, too lenient.
They would like to see a longer sentence.
They'd like to see a longer sentence. The hard part of this is, if a family loses a child to cancer or in a terrible car wreck, those things are very difficult. But imagine at Christmas time or holidays not having this boy around. And why? Because of what she and he had to say. What she had to say, and you know, she may have some issues too. Mentally, you know
and
what I mean?
Let's talk about what this means for the rest of the country in other states, because let's face it, every teenager in America practically has a smartphone. This case has to be terrifying for the parents of, let's face it, impetuous teenagers who often don't have the maturity yet themselves to calculate what they're saying. What will this be? Will this be used as a precedent in other states?
I don't think there's any question it will, and that's why the issue of whether this case gets to the Supreme Court, it's possible it will, because it has far-reaching effects. And I mean, you hit it right on the head. There's this issue of bullying, and which suicide results of that. What's the consequence there? What are the what's the penalty there? That sort of thing. There's issues of stalking online. So
any text messages now are admissible in court.
You know, they're admissible in court, and it's a different world. 25 years ago, we didn't have this. Now the law has to adjust across the country, and obviously at the highest courts. So I think this case could make it to the Supreme Court. It's possible.
And then Michelle Carter's attorneys say they wanted to, they believe it should, that they believe that she was within her First Amendment rights. Do you think she has a shot at being heard by the Supreme Court and then winning that case?
I don't think she has a shot at the First Amendment issue. She might have a shot on whether this conduct is wanton and willful enough to convict her beyond a reasonable doubt of the involuntary manslaughter. That's where she has a better shot. The Boston Globe, which is a liberal paper, came out, blasted the ACLU today, saying that, you know, it's like crying fire in a crowded blackened theater. Free speech has limitations, and this is not free speech. Badgering, the word that the judge used, badgering a person into the car to complete the suicide and listening to
The
him
idea
die.
being he wouldn't be dead had she not.
That's
not
right.
done
He was.
that.
He had doubts he was going to get out of it, but she forced him back in there.
And Liam brought this question up. Conrad Roy committed suicide in 2014. It's 2019 now. She's finally going to jail. What is it about the system that made this 4 years?
Well, you know, I don't want to defend the system in the sense that it should work faster, but there's no question that this was a process. First, the process had to be, does the district attorney's office think we have a case here? We can prove beyond a reasonable doubt that this wanton, reckless conduct amounts to an involuntary manslaughter conviction. So now you get that part of it. Then there's the trial. The trial was over. She was allowed to, the same judge that sentenced her today, knowing that the issue was so new, so, you know, cutting edge.
Right.
He let it go through the appellate process, and it takes time. If you, writing a brief and having a brief from the government and having a brief from the, you know, those things take a long time. A record has to be assembled. It does take time. Now, in this case, I think the judges, you know, if they weren't unanimous on it, it would raise more questions, but they were.
They were unanimous, and she certainly had a full hearing.
She had a full
on this
hearing,
entire
yeah,
affair.
exactly.
We will see whether or not the U.S. Supreme Court takes up the issue. Phil Tracy, always nice to see you. Thank you so much
Great
for
to be
chatting
with
us.
you, both
Thanks
of
so
you.
much, and we have got a big